Big, breaking news that every veteran and green card holder in the United States needs to hear right now. Starting October 2025, ICE is implementing a massive overhaul of its deportation policies, changes that could dramatically impact your life or the lives of your loved ones. Whether you've served this country in the military or hold a green card, this new policy could either protect you or put you at risk of deportation like never before. Do you know exactly what these changes mean? Are you fully aware of your rights and the critical steps you must take to stay safe and secure? In the next few minutes, I'm going to break down everything you need to know, from who qualifies for these new protections, what the government is prioritizing, to the real risks involved if you're unaware. This isn't just another policy update, it's a potential game changer for thousands of people. So if you or someone you love is a veteran or a green card holder, you can't afford to miss this. Watch closely, because your future might depend on what you do next. Let's begin with an overview of what the ICE deportation policy overhaul means. ICE is responsible for enforcing immigration laws, including detaining and deporting individuals who are in the country unlawfully or who violate immigration regulations. Over the past few years, ICE policies have fluctuated significantly depending on the administration in power, public pressure, and legal challenges. Now, in October 2025, the Biden administration has introduced new directives aimed at balancing enforcement with fairness and protecting certain vulnerable populations. One of the core objectives of this policy overhaul is to prioritize deportation resources on individuals who pose serious national security or public safety threats, while offering greater protections and due process for others, including veterans and lawful permanent residents, that is, green card holders. Veterans, in particular, are a unique and important group in this policy. Many who serve in the U.S. military may not be citizens but hold green cards or other immigration statuses. Their service to the country complicates traditional enforcement actions, and this overhaul seeks to recognize their contributions by adding layers of protection from deportation, unless they are involved in very serious crimes. So, what are the major changes affecting veterans? First, under the new guidelines, veterans who are green card holders or lawful permanent residents will receive stronger consideration before any deportation proceedings begin. ICE officers must verify the veteran status of the individual through Department of Defense records before making enforcement decisions. If the veteran has an honorable or general discharge, this can serve as a significant factor against deportation. Second, there is now a clearer pathway for veterans to apply for naturalization and citizenship, with expedited processing times to reward their service and integrate them fully into the community. This means many veterans can expect faster access to citizenship benefits, which offers greater security against deportation risks. Third, the new policy restricts ICE from targeting veterans for deportation unless they have been convicted of serious crimes such as violent felonies, terrorism-related offenses, or significant drug trafficking charges. Minor infractions or non-violent offenses generally will not trigger deportation actions. Now, what about green card holders more broadly? How does the overhaul affect them? For lawful permanent residents who are not veterans, the policy also introduces some important changes. ICE will focus deportation efforts on individuals who present clear risks to public safety or national security. Those with minor criminal records or those who have demonstrated rehabilitation and strong community ties are likely to be deprioritized. Moreover, green card holders facing deportation will now have increased access to legal support and resources during their removal proceedings. This includes better notification about rights, the ability to request bond hearings more easily, and enhanced protections to ensure due process is respected. Additionally, the policy introduces new criteria for cancellation of removal and adjustment of status applications. These legal remedies give some green card holders and others facing deportation a chance to remain in the U.S. if they meet specific requirements, such as continuous residence, good moral character, and hardship to family members who are U.S. citizens or permanent residents. These changes aim to provide a more balanced, humane immigration enforcement system while maintaining national security priorities. So, what should veterans and green card holders do now to prepare? First and foremost, it's essential to verify your immigration status and make sure all your documentation is current. If you're a veteran, ensure your military records are up to date and accessible, as they can be vital in demonstrating your eligibility for protections. If you have been a lawful permanent resident for several years but have not yet applied for citizenship, now is an excellent time to start that process. Naturalization applications will benefit from expedited handling under the new policy for veterans, but all green card holders are encouraged to apply if eligible. Second, consult with a qualified immigration attorney or a trusted legal aid organization. Immigration law can be complex and ever-changing, and professional advice tailored to your situation is invaluable. They can help you understand how the new policy applies to you, assist with applications, and represent you in any proceedings if needed. Third, stay informed about any further updates. Immigration enforcement policies can evolve, and staying connected to reputable news sources or community organizations that focus on immigration issues can help you act quickly if your situation changes. It's also critical to be aware of your rights during any interaction with ICE agents or law enforcement. You have the right to remain silent, to request an attorney, and to not consent to searches without a warrant. Knowing your rights can prevent complications and protect you legally. For families of veterans and green card holders, communication is key. Discuss these changes with your loved ones and help ensure they have access to the necessary documentation and legal support. Community organizations often hold workshops and information sessions that can be highly beneficial. Let's address some frequently asked questions about the policy. Will all veterans be protected from deportation under the new policy? No. While the policy offers significant protections, veterans convicted of serious violent crimes or national security offenses remain subject to deportation. Can green card holders with minor criminal records avoid deportation? The new policy prioritizes cases, so many with minor or old convictions may not be targeted for removal, but each case is unique and depends on individual circumstances. How can I find an immigration lawyer or legal aid? Organizations like the American Immigration Lawyers Association, AILA, local non-profits, and community centers can connect you with trusted legal professionals. What happens if I get a letter or notice from ICE? Do not ignore it. Contact an immigration attorney immediately to understand your rights and prepare your defense. Is there any risk this policy could change again? Immigration policies can shift with new administrations or legal rulings, so staying informed and prepared is essential. In conclusion, the ICE deportation policy overhaul effective October 2025 represents a significant shift in how immigration enforcement will operate, with an emphasis on protecting veterans and green card holders who have contributed to American society. While the landscape remains complex and sometimes challenging, this policy offers hope and concrete benefits for many.